I appreciate you flagging that, Senator. And if I'm confirmed, I would look forward to working with you and other members who I know are going to be engaging these important questions in upcoming legislation. But your flagging of the respondeat superior doctrine is certainly something that I recall actually you raising when I appeared before this body this summer. And I would be very interested in thinking about that further on these tough issues. Thank you.
Thanks, Senator Whitehouse. Senator Lee.
Thank you, Mr. Chairman. Thanks to both of you for being here. I've enjoyed my interactions with you in the past and look forward to our conversation today. Ms. Gupta, let's start with you. As you know, part of the Department of Justice's responsibility is to review the legality of agency rules before they're finalized, and then to be prepared to defend those rules in court. As part of the process, you have to anticipate what might come about. Are there any circumstances in which you might refuse to defend a federal regulation that's already been approved by the Department of Justice?
It's hard for me to opine on that hypothetically, but I believe that there would need to be some stringent circumstances that would need to present themselves in a clear rationale that would involve probably deliberation by the highest level of the department to refuse to do something like that.
Would you describe it as an unusual event in which that might happen?
Yes, absolutely.
And so what sort of circumstance would that bring about?
It could be that it's a change in the law in courts around the country. It could be that changed factual circumstances. Obviously, hypothetically speaking, it's hard for me to know, but the Justice Department would need to be able to clearly rationalize that or provide a rationale to any court were that to happen, and so I would think that's quite an unusual circumstance.
Okay, I want to pick up on something that was brought up by Senator Grassley and was also mentioned in a separate line of questioning by Senator Cornyn regarding sort of the manner in which settlement agreements are reached and how they're brought about. Senator Grassley asked you a question about the circumstances in which third parties, in which parties to a consent decree with the Department of Justice are sometimes directed, or have in the past at times been directed, to pay a monetary penalty to a third party. I believe your response was that you would follow regulations on that. Let me ask you this. When would it ever be appropriate to direct a litigant with the Department of Justice to pay sums to a third party?
So my understanding is that the regulation that is in place right now limits it to 4 circumstances. I don't have the details in front of me, but I think they're very restricted, and in part because animated, as I understand it, to ensure victims are made whole and to avoid any appearance of impropriety or favoritism towards an advocacy organization. And I understand why there are guardrails, but I don't have the regulation in front of me, but I think that they're quite restricted.
Now, under the previous administration, this practice was brought to a halt. Under the previous administration, there was a decision made that we wouldn't have litigants pay monetary penalties to a third party. Are you saying that you would undo that policy and return to the previous practice?
No, I would comply with the regulation that's in place right now. I may have misread because I haven't read this regulation in great detail. I thought there were very restricted situations, but generally the default is that it is not allowed. Okay.
The reason I raise it, and I suspect the reason my colleagues have raised it, is that it is of concern. It's difficult for me to understand why. It's hard for me to imagine any litigant, we're talking here generally about civil litigation, any litigant with as much bargaining power as the United States government has in court. And when you bring that power to bear by directing someone to pay to a third party, you're almost inevitably going to run up against a risk of that being improper. I mean, in many more circumstances appearing at least to be improper. Very often these end up going to groups that have certain sympathies that might align with the incumbent administration and their views. and this further perpetuates the sue and settle dynamic, the process by which lawsuits are brought, sometimes friendly lawsuits, friendly to the Attorney General and the President currently in power. They'll then agree to a settlement agreement and then agree that the litigant has to pay a whole bunch of money to this third party. It's difficult for me to imagine why that would ever be appropriate, and I would encourage you not to allow that and to follow the previous administration's ban on it. Ms. Gupta, about 3 years ago, I think it was in February of 2018, you authored an 8-page letter that you submitted to this committee in opposition to the nomination of Ryan Bounds to serve on the U.S. Court of Appeals for the Ninth Circuit. You raised complaints against Mr. Bounds based on comments that he had made, things that he had written while he was in college. You described those as offensive comments and made your case as to why they were. You went on in that same letter to write, while he has recently apologized for those comments, the timing of that apology suggests that it is one of convenience rather than remorse, offered in a last-ditch effort to salvage his nomination
out live in the
and
hearing.
win
Is
the
this an
support of
audio
his
test
home
from-
state senator.
Test from Senate recording.
Ms. Gupta,
1, 2, 3.
do you stand by the standard that you articulated to us when we were considering the nomination of Ryan Bounds?
Senator, thank you for that question. For decades, the Leadership Conference has reviewed the judicial nominees in Republican and Democratic administrations. And when we have reviewed it and decided to oppose, we've provided a letter to this body. And actually, in the Trump administration, I think we did that in about a quarter of the nominations. And we did it based on a complete review of a nominee's civil rights record. And I believe that letter that you're referring to was the review of his record as we were presenting information to this committee.
Yes. No, I understand that. I'm asking in part because I'm curious about your reaction to his apology. So he wrote some things in college. He later apologized for them, realized that they were offensive and not things that he would say today. You told him that his apology was too late and too self-interested, too connected to our consideration of his nomination. So my question to you is, would you stand by that? Is that something that we ought to apply to all nominees? Is it something we ought to apply to you, to Merrick Garland, to all Department of Justice nominees?
Well, Senator, I do regret the harsh tone. I think that this is what you were getting at, and forgive me if I'm overstating, but I apologize for the kind of coarse language that I have used in the past. I would hope that you could look to my whole demonstrated record of working with Republicans and Democrats and conservatives and libertarians and progressives on any range of issues, really from very early on in my career. And you have my word that I will look forward, if confirmed, to respectful, engaged dialogue and engagement with this committee and with other members of Congress, even if we have policy disagreements and the like. And so my hope is that you will take that as genuine and authentic.
I still don't understand. I would love to know how that is different from Ryan Bounds. Ryan Bounds gave us almost exactly the same answer, that his career, his comments should be viewed as a whole rather than on the basis of a few things that he wrote while in college. That's what I'm asking. Does that standard also apply to you? The standard that you very harshly applied to him, should it also apply to you and to Merrick Garland?
Senator, I believe that people should be able to have second chances, and so to the extent that a comment in the past about this judicial nominee, I believe that it was about substantive comments he had made in college writings. But as you know, maybe from my criminal justice work, I am a believer in second chances and redemption, and I would ask for that today to the extent.
Thank you.
Thanks, Senator Lee. Once again into the breach, Senator Leahy. We're hoping for the best.